everyone. Welcome to IP Watchdog Unleashed, where each week we journey into the world of intellectual property to discuss the laws, news, policy, and politics of innovation, technology, and creativity. With analysis and commentary from industry thought leaders and newsmakers from around the world, IP Watchdog Unleashed is hosted by world-renowned patent attorney and the founder of IPWatchdog.com, Joel Quinn, who has twice been named one of the most influential people in the intellectual property community and recognized numerous times as one of the top IP strategists in the world. Take it away, Gene.
Thanks, Renee, and welcome everyone to this week's edition of IP Watchdog Unleashed. This week, my guest is Joel Meyer, who is an IP attorney and innovation strategist with more than 30 years of experience in the industry. Joel has been recognized repeatedly as one of the top 300 strategists in the world by IAM, and he has a track record of successfully building and monetizing IP portfolios. Most recently, Joel served as Vice President of IP and Innovation Strategy for Digimarc Corporation. He left Digimarc, which for now I'm going to say that in air quotes, and we'll come back to because I'm not entirely sure he's really left Digimarc, but he left Digimarc over a year ago officially, at which time he started his own boutique law firm, which focuses on IP and innovation strategy for funded startups who are looking to aggressively grow because they understand the importance of IP. They need somebody like Joel. So now he's left Digimarc in those air quotes, but he continues to do work on behalf of Digimarc, which I find interesting. We're going to ask him about. And he is also now Chief Corporate and IP Counsel for Transformative Optics, which was founded by the founder of Digimarc. So Joel, thanks for being here today.
Dean, thank you so much for having me. It's a great honor. You do such a great job and a great service to the IP community by keeping us all abreast of the latest, greatest happenings in the space and the best, the best practices in IP. So I'm really honored to be part of the conversation today.
Well, awesome. I appreciate you being here, really. And I know you've been on our stage before at IP Watchdog, and it's great to have you back and introduce you to our wider, probably much wider podcast audience here. So let me just jump in. And I guess where I want to start is for us to begin to talk about what it is that you're doing today. And based on what I think I know, you haven't really left Digimarc in sort of the classic sense where people work for a company and then you move on. You just have now more flexibility, it seems, to do other things, including working for related companies, working for other startups. So feel free to tell the audience more about what you're doing now, and feel free to correct the record if I got anything wrong.
Yeah, sure. And I thought I'd maybe just kind of give people a little bit of background about myself too, in the process of covering that topic. I have started back in the first digital transformation back around the late 90s, 2000. And I think one of the key themes of our conversation today is to talk about, these waves, the first digital transformation, the .com era, the high point perhaps for patents and patent value, and then kind of the pendulum swinging one way and then perhaps back again, and now we're upon another very disruptive innovation around the knowledge space and AI, of course. I have a background in deep tech, electrical and computer engineering, and I was trained in private practice. But as you point out, a long part of my career and where I really kind of developed the cross-functional skill set within IP was at Digimarc, where we built a portfolio. We aggressively pursued both a product business as well as licensing of the patent portfolio. There were a lot of sort of ebbs and flows of the business in terms of different use cases of the technology, and with kind of the recent ebb and flow of technology, I moved out. I continue to represent the company, but I also have an opportunity to build my own firm and work with startups like you said, Transformative Optics as well. So always keeping my kind of finger on the pulse of IP and how to create value and drive value, regardless of where we sit in these transformative moments.
Yeah. So let me give you an opportunity to tell the audience a little bit about Digimarc and their technology specifically, because I think that's going to become relevant to something we want to talk about, like the shifting tides and some things change and then they boomerang back but what is the Digimarc technology?
Yeah, the Digimarc technology is a signal processing innovation in which you embed information in content of all kinds. It could be an image, audio, or video, and it can be used for a number of different applications. Essentially, it's an auxiliary data channel within the content itself. So in the first digital transformation, there was a real interest to say, how do we're now content is now yearning to be free on the internet, in the digital realm, and Napster. And so now that we don't put it in a package and sell it on a piece of plastic, how do you deal with this? Well, a digital watermark can be embedded in the content. It doesn't impact the visual or the audio quality, but it can signal to devices and provide copy control. So the industry at that point was very aggressively trying to figure out, how do you put the genie back in the bottle? How do we stop people from copying and ripping and burning in a way that isn't authorized? So digital watermarking kind of had a big play there in terms of not only controlling the use of content, but also kind of tracking where that content would go. And so that was kind of the first really big wave of the technology. And then today, it's sort of kind of coming back around, because there is this challenge with this proliferation and plethora of artificially generated content, synthetic content, and how do you assess whether something's real or not? And watermarking is an interesting way to do that, because you can invisibly label content and you can say, where is it from? That's often called the provenance. Or has this content been modified, and in what way has it been modified? And the watermark can help assess that, and it can also associate persistently information with the content that it can be used to authenticate it. So it's kind of having, now as we talk about these two major transformations, the digital transformation and the AI transformation, the watermarking kind of plays a role there. It's also, kind of, we've talked a little bit about, functional claiming and software, but signal processing is kind of an interesting beast in that over the years, it can be implemented in hardware, software, firmware, and a combination thereof. And so, we kind of went from a regime where, everybody back in the early days of patent pools thought about video coding and patents. Clearly, that video compression could be patented, and it was a big part of the early formation of patent pools. But through this whole winter of IP, of patent protection, we kind of went through, and everything that was could be deemed abstract, was seen as perhaps not patentable. And now we're kind of reckoning back with, okay, maybe we ought to pull back and sort of now recognize that, yes, this technology, it has some level of abstraction, as any other technology does, but it's hardcore science, and it can be implemented across hardware, software. And so it's really not so much an issue of, software patentability, but really patentability of core technologies, and at what level do you try to patent them? What level of generality? That I think is interesting.
There's two things that come up in that answer that, I think beg further conversation. One is, when I hear you give that answer, I am reminded of what David Kapos always used to say, and maybe he still does say it, but certainly back when these debates were going on at the very beginning, after Alice and leading up to Alice, talking about software. He came from IBM, and IBM is one of the true software juggernauts in U.S. history, right? And he always pointed out that whether you do this in software or you do it in hardware, for example, that is a design choice, because you could do all of these things in a variety of different ways. And I don't think enough people really understand it, certainly not the policymakers. And I'm afraid the judges don't understand it either. And I heard a little bit of that in your answer too. Maybe you could comment on that. And then the other thing I want to talk about is, artificial intelligence in general, I think has a lot of value because by its very nature, it is abstract. we don't know exactly what it's going to do, but that's what makes it useful. If we knew exactly if it was A to B to C to D then to E, and it was just this linear, or even if it was more complicated, A to B, but if C then D, you could chart it all out, then it wouldn't be intelligent. It would just be a predefined roadmap. But with large language models like they are, I think these tools are becoming much more intelligent. I don't know whether they're true consciousness, certainly not true consciousness, but how intelligent they are along the line there. But the abstractness is what it makes it special. So if you can't patent it because it's abstract, I don't know what to do exactly. And so there's a couple thoughts there on the table. Feel free to pick one and we can go from there.
I think that's exactly right. The way that signal processing technologies are developed, at least as I kind of cut my teeth with working with really well qualified algorithm engineers and PhDs throughout my career, you start with ideas, you start with algorithm designs. Dare I say algorithm? That's another problem with abstractness, but really it's an advanced algorithm, and you might start in MATLAB, and then you might have an optimized C version of that, C++ version of that, or you might optimize it and say, well, it's got to run at the network edge, and so we got to get down the memory bandwidth issues, and it's got to run in real time. And all throughout, this whole Alice conundrum that we've been talking about, well, this can't be done in the human mind, or the human couldn't do it in real time. And so those are all little things along the way. But yeah, that's it is a design choice depending on the requirements of where are you running this, and as AI moves to the edge, well, look at what we're seeing. You need special purpose hardware or advanced processing hardware to do it. We see the future of AI being those that control compute. And so you have the GPU, this general purpose workhorse, but guess what? You've got TPUs by Google, and now you've got Musk, and Terafab, and trying to leapfrog everybody else. And it is really fascinating that these are concepts that are abstract at some level, but it is an implementation choice. Yeah, and I think in terms of information, it is really fascinating. I think generally when you're trying to replicate what it's kind of putting things on its head. It's like, well, can it be done in the human mind? No, this is actually a machine trying to replicate the machine learning and the thought process of a human. And so is that abstract? I think it's really at some level, and I think, you and I talked about this, is that I honestly believe that the world had this problem with eligibility and confounded eligibility with 112 and written description and enablement, because they really just didn't have a good basis for assessing functional claims and finding prior art. And so, well, we can't find anything. We don't have a corpus to search this or find this. So, well, it's too abstract. It's just too general. And well, what if it's new and useful? What if it, so I think, that has led to the problem. Now, sort of, we've kind of gravitated toward this basic theme of, having a technical solution to a technical problem, adopting some of the European views. And I think that's kind of where it sits now, and where it's going to continue to head, is that if you, really describe something in the technical improvement and how it impacts the world, but you also have really good, detailed description of some of the embodiments and how they improve this and provide a technical solution, I think we'll kind of get out of that. And then AI is no different in that sense. It will be, how are the architectures of AI, not just, apply it to a machine learning, but how did you improve the functioning of the training process, the inference process, and so forth. And those are all inherently, signal processing improvements, again, that fit that same model of, design choice and how they're implemented in hardware, software, or the like, or some combination thereof.
I think you're exactly right. A lot of this is more 112, and to some extent, maybe even more 103, but I think a much more 112, where you read some of these legacy patents and there's just nothing there other than really a wish list. And that was considered appropriate for the time because people were able to get patents on that stuff. So I'm not going to throw anybody under the bus that wrote stuff like that because, like why do you need to go through and write a magnum opus? You don't need to write Moby Dick when a Curious George volume will suffice,
Yeah.
And and so there was some of that, but I also think there was a lot of it that was just functionally we we collectively, I guess we collectively, I didn't agree with this, but I think the whole industry, more by and large, at least the policymakers and the judges, came to the determination that there was a whole lot of bad patents out there. We need to get rid of them. And if we do it with patent eligibility, then the courts are going to have the opportunity to get rid of these cases on a motion to dismiss. I don't know that how that all got planned out or whether it just kind of happened that way, snowball rolling downhill, gain momentum, but that's precisely what has happened. And none of this deserves to be a 101 as far as I'm concerned, but it does deserve to be considered. If there's no there, then I don't understand what the problem is. You're not entitled to a patent. But if there's a there, saying that it's abstract simply because it has broad coverage or does really cool things or it's science fiction kind of come to life strikes me as the antithesis of what we're supposed to be doing.
I like your point about 112, and I think the patent office in the past and over history and the arc of our careers has been really challenged in really assessing 112 and enablement issues. Is there a technical, is there enough algorithmic detail there to enable someone to make and use the invention? And I think that I have this hope that with AI tools, with AI tools helping drafting and kind of finding the best art and having the most knowledge of what is going to be impactful in the market and what's the true innovation over the prior art, and being able to tease out embodiments at multiple layers of abstraction in the specification is going to lead to higher quality. And then similarly on the examination side, a much more streamlined examination. So I think, we often, when we get into these conundrums, we say we should all be joined together to improve patent quality. And I think that's true. And I know, it's interesting, your webinar yesterday, there was a number of people talking about patent office and using AI, and people are like, well, that's going to be the most awful thing if AI is doing the drafting and doing the reviewing. Well, probably so, but if you have human curated AI assisted help to drive the highest quality on the front end and the highest quality on the review side, I do think we do have a path through. So I'm more in the view of the positive side. Let's drive value there in terms of addressing some of the problems with patents that we were just enumerating with these AI tools.
I'm very much an optimist when it comes to AI, and I think it makes you better. I think it makes the work product better. I think it's starting to speed you up a lot, particularly the more you get to use it. I don't think it's ready for some of the in-house people want like 80% reduction of fees from what I'm told because of the AI. We are not there yet. And my fear is that when you look at people who do want that kind of dramatic reduction in fees because of AI, you can do that, but there's not going to be a human in the loop. Then you're just going to be paying for what the machine spits out. And I think that's one of the problems is we've seen this laziness with litigators who ask AI to draft a brief and they don't even check it and they submit it. And we're still seeing fictitious cases find their way into briefs and lawyers getting sanctioned. And I think the fear is just knowing human nature. Maybe that's it. I mean, and I suppose people will continue to be lazy maybe forever with it. I don't know. I hope that's not the case because if you don't take it seriously, you're not going to get out what you need. And if you're not going to get out what you need, sooner or later, companies, firms, governments are just going to throw up their hands and say, it was nice in theory, but it's not playing out in practice. And I think that would be terrible. Okay, let me try and pivot a conversation just a little bit, and it's not necessarily get away from AI. If it comes up, that's perfectly fine. But one of the things I wanted to talk to you about was what it is that you're working on now that you find interesting. And I want, as an attorney, be mindful of the fact that you can't tell us who your clients are necessarily. And some of your clients are probably startups in stealth mode anyway and don't want to be identified. But what can you tell us about the technologies that you're seeing that are out there that people are working on that are getting you really excited for the future?
Yeah, I think I'll take the opportunity to talk a little bit about transformative optics. The technology. This was, as you noted, it's a company founded by the founder of Digimarc, and it has two primary technologies. One is what they call AI CMOS, which is a way to get additional information out of a CMOS sensor beyond just the standard colors, red, green, blue. And it also has a foundational technology around array cameras that can do imaging faster, higher resolution by combining imaging modules together and then fusing the images together to get higher performance rather than trying to build ever higher, denser sensors. And both of these things, I think, are really at that key inflection point. We call it AI CMOS because it's really looking at the floodgate of data hungry AI and being able to have the type of data that machines can discern more than what humans can and draw insights from that. And so I think that's a compelling area is what's that hardware interface to the data, the floodgate of data that's going to need to fuel all of the AI applications into the future, and how do you do that optimally? So I'm really excited about the continuing to operate on that sort of physical to digital interface. Those technologies I think are great. And then I have to say that I think just the strategy piece. We're in a huge transformation and disruption, and there's a lot of development around AI applications, and just the strategy piece around how do you protect something when everybody's coming up with their own sort of innovating, and everybody can be a builder. How do you effectively protect that? And just weaving through in this age, what's the strategy there when you have this technology? And it's really fascinating to think through that for small companies and think through, is this a trade secret or is this a patent? What good is the patent going to do? And then also juxtaposing that against what's happening in the market among the foundation models as they leapfrog each other. And there's this debate about is a private company with a private model going to win, or is this open source model going to win? And how does that play back into the patenting strategy for applications of AI, given that the foundation, the knowledge base might be actually starting to get, and dare I say, commoditized, because there's always, somebody who's going to be left ahead. But, the strategy piece and having to be nimble and come up with new strategies and do it on a limited budget are a couple of areas that I think are really exciting.
Let me ask you more about that, because I think during my career, when we first started, and I suspect you were the same, we're probably very similar starting times within a few years of our beginning of our career. You just get a patent. You got to get a patent. You got to build up a portfolio. Patents are valuable. Somewhere along the way, that didn't become the case. They became less valuable. I think a lot more people went to trade secrets, particularly in the software area. Just keep it secret, put it behind a wall, software as a service. We're not selling disks or selling software anymore. You got to log in and use it, and it's protected, and changes the business model. Maybe not completely because of patents, probably also because of some copyright concerns as well, and monetization, certainly. Where are we now? Are we in a place where these startup companies, let's say just AI space, I mean, everybody's got an AI play anymore, it seems, right? Should they be thinking patents? Should they be thinking trade secrets, or maybe even more importantly, when should they be thinking patents? And when should they suffice with trade secrets, in your opinion?
I've been a primary benefactor of firms that file and just want counts, patent counts, because that's
Mm-hmm.
obviously what fuels the IP practice and pays a lot of paychecks. But I also think that I worry that just filing patents and your sentiment earlier about, well, firm the companies just expect it's got to be cheaper, it got to be cheaper. It's like, well, we should be value based, right? And
Right.
so when you think about value based in startups, it's like, okay, yeah, you don't have the barriers to entry. You're not a network effect platform where there's stickiness to the platform. You want to be that, but in the early stages, you have some new concepts, some new ways of doing it, new ways of applying AI. So I think you can develop a patent strategy with some of the bigger ideas and use kind of skillful drafting to kind of get the implementation detail you need to get the how and get over the enduring eligibility challenges. But do that. But then as you refine the business, you don't necessarily need to patent every optimization. You can have a lot of trade secret and know-how that's built on top. So I think there's always been this. I think there's always the duality of having early and often filings that capture the patented technology very well, and then optimizations that are maintained as trade secrets. And I know one of the things that we talked about in the Patent Masters program that I was involved in a year ago was just my philosophy of how do you build a really solid specification so that when you have in the early days, you can patent things, or you can think about what's the sort of the physical layer in this network stack modality? What's the algorithm layer? What's the hardware implementation layer, like we were talking about in terms of how you implement that? And kind of planting that seed so early on before you know how this is going to track out, but giving you optionality. So that's what I endeavor now with startups, is to say, you're going to be disruptive, and when you are, you're going to have asymmetry against those that are in the status quo, that are seeking to block you or overroll or run over you. And so, I think patents serve that role. Trade secrets definitely have a role as well, but I think early on, you really do want to try to build a foundational patent specification, and you can try to do that if you think about all the different levels of the system where this technology is going to be used, and you set it up for optionality downstream.
That's music to my ears. That's what I've always preached. I don't think enough patent attorneys pay good enough attention to the specification. And maybe it's the function of the clients, right? We've already been kicking this around, but the big clients, a lot of the biggest clients who are patent acquirers, are acquiring massive numbers of patents. They don't need any one patent to be everything. They often want numbers rather than, a high quality patent family that can grow, because they know they're going to want patents. They know they're playing a numbers game. They know in certain areas, they're going to try and license not a family, but hundreds, if not thousands of families. And they come in and they'll say things like, well, we've got all these patents. Surely you're using some of them. So why don't you just take a license to the whole portfolio? And there's a lot of logic to that. And that business continues to go on, but I think you have to be of a certain size in order to have that make sense, where you then have everybody else. Whereas if what you're doing is doing work based on the biggest companies, and then a startup comes to you and you draft the patent claims first, and then you draft the specification to the extent of the claims you filed, while that might work for a Fortune 100 company that has 10 plus thousand patents in their portfolio, that is not a strategy, in my opinion, that works for a startup, because they need to plant the flag. And if this is successful, they need to be able to expand the portfolio.
Well, and I don't want to over-index on the impact of AI, but it is just sort of so ubiquitous. And as we chatted a little bit about the other day, a lot of times what you'll have is a client will come to you with a fully written specification because any foundation model and various drafting tools will create a full-fledged patent application. It looks like a patent application, talks like a patent application, walks like a patent application, but it's essentially a product specification and has someone really looked at it from the lens that we were just talking about. What is this product in the marketplace? Who are the competitive? What are the competitive threats? What are the alternative technologies? What are the legacy technologies, and how will they combat this? How do you use this with the legacy technologies? And so you almost have to like do surgery on it, or you have to kind of start over and say, okay, here is the initial product specification, but let's look at, what is the true innovation here? How does it juxtapose against the market? And what are some aspects, really fundamental aspects that can support a patent strategy down the road. So then back out the detail. It's great that you have this detailed, sort of product specification. You don't want to necessarily lose that, but you want to kind of think about it. You want to take a step back. And so, but I think again, to my point about quality is I think you can very quickly come up to speed on a market, very quickly come up to speed on maybe some prior art by using classical search tools and AI assisted tools, and then say, okay, client, you've got this product specification, but it's going to be hard. You got to think about who the infringer is, how this is going to be used, the different types of products. It's going to be international, geographic cases where where is the infringer? Is there divided infringement? And then pull back and figure out like how to structure the claims in families of claims in that first filing, and then go back and restructure the specification to really fully enable all of that, so that you have that specification enabled from very high levels of abstraction, challengeable on being too abstract, to multiple levels. Now, obviously you can kind of go overboard there, but I think if you pick things like, okay, I'm going to want to have 3 levels of generality for every block diagram I have, and write a hierarchical specification. I think that with that discipline and giving that, and you can even use the AI tool and say, here's the plan. I've got these components. I've extracted them up from the new broadened claim set. Let's lay this out so that we have the highest level of generality, that we have all the modules, and then we break those down into levels of detail. So I think that the tools can do that, and then you can also you can kind of do what we didn't really have a lot of ability to do in the past, which is to do a really good search. Now, when I was in-house, you develop this organically over time because you were in the field, you were in the business, and you went to conferences and you kind of gathered all the prior art. But now you can use AI tools. There's a company, Fluidity IQ, that has this concept of a private invention library where you can create this living, breathing corpus of knowledge about the space around an invention. And as you take that patent through the life cycle, you can grow and shape that, but you can always kind of build with a really good understanding of what the space is, what the prior art is, and it's never static because you always discover more as the world goes on. That's the strategy. And kind of going all the way back to Digimarc and what I'm doing for Digimarc. Well, now 30 years later, watermarking is resurging in a form of AI-based watermarking that the big platforms are doing. Well, what does a company like Digimarc do that now its day in the sun has come yet again for another use case? Well, if you haven't really taken this philosophy throughout the portfolio building process over the years, it's like, well, okay, now the day in the sun has happened, but I'm completely out of luck, right? But if you've actually had a concerted effort to kind of build over time, and you're always looking for those threats and those opportunities, you can kind of build that into your process, and you can kind of handle the asymmetry of a small company versus the platform players.
And if you started, like you said, with a general description and then layer it with more specifics, and focus at all levels on the technology, that's how you then have a platform that has meaning for a certain technical reality. And then also later for potentially other technical realities that are going to build on that same layer or the same logic. And that's just, I think, critically important. I want to go back though. In my experience, the client who comes to you with that document, they always think it's much closer to a fileable patent application than it is. And I've had so many, because I spent a big chunk of my career working for truly small companies. And you don't want to discourage them for trying to be involved, and they're excited and they want, but they get an unrealistic idea of costs in my experience, because they come, and I can't tell you how many people will come with what they believe is a nearly complete application. And all they need me to do is just in an hour or two of my time, review it and make it better. And I'm like, okay, well, even if it was a perfect application, there's a little, I mean, I can maybe go through and see if you're using patent profanity and things not to say, or if I have questions, you didn't describe this well enough, but I'm not going to know the invention. I'm certainly not going to know the prior art in an hour or two. There's a very limited amount of stuff I can do as a patent attorney. Any patent attorney can do with that kind of restriction. So I think the real secret sauce is letting your patent professional use these tools and then cooperating with them to give them the information they need about the invention, which is where a lot of companies fall down. They reasons I could never understand. They don't want their inventors to talk to the patent attorney. And I guess you got to be guarded to make sure the patent attorney isn't being abusive and taking up too much of their time. But if you don't let them talk to the patent attorney, how can you expect to capture what they actually invented? That it just seems fundamental to me. And so I do think that there's a lot of important use cases for patent attorneys. I don't want to discourage clients from trying to be more involved in this situation. But just like Goldilocks and the Three Bears, there's a just right solution here. And AI makes things easier, faster, better, certainly a better work product, as I've said many times, but I don't think it changes the fundamentals of the relationship. Cooperation is important. Describing the technology is critically important. And having a vision is important, and knowing what you want to do. Because if all you want is patent numbers game, we can do that. I'm not too interested in that. I doubt you are really either anymore. That I've been there, done that. What makes me get excited is helping people who have something exciting that they can grow with.
I think that the key to value is information, and that's why, working in an in-house modality. I started in private practice. I represented, large clients and they had interesting cutting edge technology and researchers doing groundbreaking work, but you were just a tiny piece and you never really got enough of the access you were talking about or the information flow to see the bigger picture. And so I think more and more, what I was able to do in my career was kind of work in a cross-functional mode where I understood, the business, I understood the technology, and I understood how the legal frameworks as it shifted over time could help to create value. And I think that's where the real value is. It's, we AI is here to stay. Clients are going to generate it. In-house attorneys are going to run, going to have guidelines where they're going to run every application from a law firm through the AI and do QC. Great, wonderful. That's going to add value. But the real thing is like, what is the strategy, and what is the humans doing to drive that strategy? And you can't really effectively drive strategy without a really good sense of the information that you need, the market, the technology. And like you said, in the bygone era, you really wouldn't have that information. But now if you work with a protected sort of information secure platform that your client endorses, you can dig around and say, okay, give me, what's the landscape here? What are the, if we go this broad in claims, who's likely to, where are the risks there, and dare I say white space analysis. I know that's somewhat of a holy grail topic, kind of proving where things aren't, which is always very interesting. But yeah, I think that it's that access to information and the role, and it's probably more, oriented. This profession will go to more value creation, and there maybe needs to be more metrics that companies have around value creation as opposed to numbers. But in any event, we're always going to have the numbers game because that's a very objective thing that people can measure. But I think more and more it's going to be, do you have the information to be able to assess what the AI is giving you and use it effectively to create value?
Value is where it's at, certainly for growth companies, certainly for startup companies, many of whom are going to wind up getting acquired at some point, and many of them who are going to be bigger and just need more investment. And you got to go to the shareholders or prospective investors with something. And those people are very sophisticated, and I don't think that group of people who are the ones that are given money to the technology startups are swayed anymore by the numbers game. The numbers game has a role, like we're talking. Like if you're a big company, a big licensing component, you got to have stuff to license, and having a library of stuff makes all the sense in the world. But when you're a startup or, even a pretty decent sized SME, you don't have enough money to do everything you need to do. You're always triaging.
Yeah.
That's the interesting thing about being an entrepreneur, right? If you break it all the way back down to one person in a dorm room trying to be an entrepreneur, there's 100 things you need to be doing simultaneously. Well, guess what? You can't do them simultaneously, but depending upon which expert you talk to, which consultant you're talking to, which issue you're dealing with, you got to do all of these things and they need to be done right now. Well, take a deep breath. You got to figure it out. And that's one
Yeah.
of the exciting things, but it's also, I think, one of the scary things about startups, entrepreneurs, and even all the way up through SMEs.
I think there's a lot of value that the IP specialist can give. If you think about a startup, there's still the concept among the investing community about moats. I think one of your recent webinars or podcasts were talking about, the Shark Tank, and they're always like, "Hey, do you have a patent on this thing?" Well, that's
Yeah.
kind of the simplistic form of it, but the IP attorney and strategist can say, "Okay, let me see your pitch deck to investors and how they want to see the moats. Like, where's the protectable advantage? Where's your differentiation? Why are you going to win? How are you going to be disruptive? The whole thing about you can't just be, better. You have to be 10 times better or 100 times better to supplant the legacy technology. Well, the patent attorney, what about the moats? Well, that's if you're thinking about your IP strategy, you're the person that's helping create the moat. So you should be there helping articulate what the moat is and getting kind of the perspective and the feedback from that channel as well. So, that's when startup companies come to me and say, I need to, I got to think about patents. Where is it going to bring value? Well, what is your pitch? How are you differentiated? And then as part of your pitch, your differentiation should flow right into, all that structured specification we were just talking about, right? That you've seen the technical, the advantage that you provide, and then you can provide some guidance as to how to articulate the moats, or at least it's a give and take. I mean, the attorney again doesn't know everything, but it's like you say, well, if this is what you think is great, how is this going to translate into a revenue stream and a protectable revenue stream? What are you going to do when the platforms decide that that's a really cool feature and they're just going to incorporate that uh, in an inefficient, infringing way into their platform? Well, okay, this is we're going to have some optionality here with this. We got product strategy, as I said, and that's kind of the basis that I've always been in. I've always been in sort of optionality. Like we can go and license this, but that's a tough road. We can go and productize it. You kind of have to do both. You had a gentleman on that talked about developing products and prototypes of products, and it was that the big thing was validation, right? And if you validate the product, how do you validate the product if you don't actually make a product yourself? That was a big part of it, and that's not just mechanical devices for for golf or for sports or things like that. It's also high tech areas. You want to be able to have some validation as well. So I think having optionality of a product strategy, a service strategy, a licensing, a software strategy, and and a naked patent licensing strategy, if things go a certain way, is something to keep in mind in that from a strategic standpoint.
Keeping your options open is critical. And I always have tried to tell startups, and I'd like to get your thoughts on whether you agree with this. You don't necessarily today need to decide whether you're going to make it, whether you're going to license it, whether you're going to build the company, try and sell the company, whether you're going to run the company yourself, whether you're eventually going to hire a CEO. It's at the very beginning, focus on the technology, get the technology right, focus on protecting it in case this actually does hit the home run that you think it may be. And then if you're doing that, which all of those possible end game realities require that to happen, then along the way, you can choose, oh, okay, well, we're going to go this way, or we're going to go that way, or we're going to pivot. And so that's one thing I always used to say is like, take a deep breath. Yes, lots of choices, lots of things for you to do all at the same time. But regardless of the path you ultimately find yourself on, let's focus on the things that you need to do regardless.
And I think there's a role, you can be a really effective capturer of IP where you've got good technical skills and you can kind of see the invention. But I think you can also be a catalyst for new innovation. As if you understand the disruptive threats that certain technologies pose, you can say, well, we're going to get outflanked here, or yes, your solution is this, but there's three other competing technologies that could probably do the same thing at some level and achieve the same function. How do you look at those competitive threats and weave that into your strategy? I know I go back a lot to the Digimarc strategy, where the digital watermark was a way of identifying content by putting an express deterministic identifier into content. But over time, AI got better and better of saying, I can identify that thing by my training. Well, if you sit there and build the portfolio only focusing in on I can only do this one way, I'm 100% into deterministic identification, and you haven't thought about, well, these probabilistic models actually might work, and there's actually a continuum between pure statistical deterministic, it's nothing is really ever that in the world, and fully probabilistic, then you can kind of build then you can start to say, well, there's a big disruptive threat. You can do all of this thing that I can do with a watermark with an AI tool or an AI object recognition algorithm. We're done. Well, maybe you build the two together, right? And you kind of incorporate the best. And so your company comes to you and says, we have this new algorithm improvement of improvement of an improvement. And we've got to get better because we got to do better performance-wise against this AI approach or this fingerprinting approach. Well, wait a second. Maybe we should be, improving upon their approach and getting, doing a hybrid of that, but also kind of figuring out where their part is weak and how these things can be used together. So I think that's that's part of the strategy as well, is not just kind of being thoughtful and taking the time to build the strategy, but also being a catalyst for where you need to be doing further innovations. And I think that's the joy of like the role of the IP Council. And as we go into this information age, I think it'll be more along the line of giving the professionals the ability to stand on the shoulders of the AI tools and the experts and be able to provide that level, because I think the information is going to flow so much more freely that it'll allow that higher level thinking as we look at the disruption of AI.
It is interesting because I think what you're putting your finger on is attorneys like us, we can actually play a meaningful role in business consulting by having these conversations, focus on the technology, and then ask, what do you want to do with it? What could other people do with it? How might they try and get around it? What might the next generation of this be? Those are all very important business questions that sometimes founders and those others who work in startup companies don't always think about it, because they miss the forest for the trees sometimes. But those business choices, those business considerations, the gaming out of the future, so critically important for an asset that could last 20 years. And if you're not doing it, you're just not doing yourself justice. And I agree with you. I think AI gives us all a lot more tools. And this is why I went to law school, to do this stuff. You didn't go to law school to be in a room with no windows with them piling cartons of cardboard boxes with documents up to the ceiling, and you spend 8 to 12 hours with no sunlight going through for discovery, right? I mean, we all probably started there, or most of us or many of us started there, but that's not what the exciting pieces is. And I do think AI gives us the opportunity, a segue to the exciting, fun stuff a lot more.
Thank you for listening to IP Watchdog Unleashed. We will be back next week, and we hope you will join us again. In the meantime, please be sure to visit IPWatchdog.com to read all the latest news and information about what is happening in the intellectual property world. And also be sure to subscribe to our free daily email newsletter.